Okay, is the microphone on?
There's one here.
Okay, great. I'm sorry, ladies. Sorry to interrupt you.
So much.
Sorry.
All right. Well, thank you again to all of you, and thanks to those joining us via webinar. We've just both briefly introduced ourselves. I'm Hillary Richardson from the National Immigrant Justice Center.
And I'm Meredith Turner-Woolley from Hughes, Socol, Piers, Resnick, and Dim.
So I'm going to give a little overview of the history of SIJS in Illinois, just to give you a little bit of context about the changes that we're seeing with this great new law that we're going to be talking about today. So SIJS, the original SIJS, was created with the Immigration Act in 1990. It looked pretty different than it does today. It required children to be declared dependent on a juvenile court in order to qualify for this immigration status, and that they be eligible for long-term foster care. So it was a pretty specific and limited group of children who were eligible for SIJS under the immigration law at that time. Then Illinois in 2003 passed a state-specific law that incorporated the then version of SIJS into Illinois' law within the Juvenile Court Act, which governs neglect and child abuse and neglect proceedings. And so that section of law included those dependency findings and long-term foster care requirements that were created by the original federal laws. Modern SIJS, as we know it today, and we'll go into the details for those of you who are not familiar, it was created by the Trafficking Victims Protection Reauthorization Act of 2008. There were a lot of amendments, but basically it removes the long-term foster care requirement. It allows children to petition for SIJS based on harm by only one parent. So it doesn't mean that a child has to be alone in the world. A child can be living with one non-abusive parent and have suffered abuse, abandonment, or neglect by only one parent. And there are a few other specific requirements that we'll go over in detail in this statute. After the TVPRA of 2008 created modern SIJS, the federal regulations still have not been updated. So there was, I think, a lot of confusion among state courts about exactly how to apply this more modern version of the federal statute. So fortunately, and during that period of time between 2008 and 2019, in Illinois, for example, the only reference in Illinois state law to SIJS was in the Juvenile Court Act and in the context of these abuse and neglect proceedings, and referred specifically to requirements that really no longer existed. And so for those of us who are practitioners trying to get SIJS predicate orders for children, for example, if I go into domestic relations court and try to explain, I want this thing from you, domestic relations court judge, it's based actually on an immigration statute. I know you're not an immigration judge, and actually the federal regulations aren't even updated, so that's not really what it's about. And I know that there's Illinois law on this, and that's not really what it's about either. So, but can you please, that was a position a lot of us were in, of trying to explain to judges, and judges were understandably a little reticent to grant this strange form of relief that didn't appear in their governing statutes, and in fact was part of immigration law, which felt kind of weird. The law of 2019 that we're going to be talking about is a huge boon to those of us who are doing SIJS predicate order work, because it clarifies a number of things. It updates the Illinois language so that it is now in line with the federal statute with modern SIJS. It eliminates those old long-term foster care requirements and dependency requirements. And it incorporates SIJS language into every governing statute in any type of court in Illinois that governs child custody. And we'll go over which statutes specifically are covered. So again, huge thanks to the House and Senate champions, Representative Gon Gershwitz and Senator Castro. It was signed into law on July 23rd, 2019. Important thing to note is that this law currently doesn't go into effect until January 1st, 2020. We're counting on you, Representative, to try to move that date up. Even if not, I think we've had great success just mentioning even that this law exists, because it's good to be able to direct judges to say, this is where the law is going anyway, just so that we're clear. I think that gives us a lot of cachet to be able to make our arguments in state court. So the law specifically protects children regardless of where they are in Illinois and regardless of who acts as guardian. As we can go into a little bit, there has been some confusion kind of in different courts across the state, including for a period of time in probate court here in Cook County about whether a judge in fact has jurisdiction to enter these specific findings. And that meant for a long time, children who are living with a non-parent, typically that would be entered as a guardianship case, right? A non-parent who wants to have some sort of legal authority over a child would file for guardianship. But because that wasn't an option for us in Cook County, those non-parents were having to take an alternative route of trying to seek an actual non-parent custody order instead in order to get those needed SIJS findings to protect the child. So this law, because it makes the findings mandatory and because it requires, it places the SIJS language in every statute, it opens a path for children, regardless of who their guardian is, to seek those findings in state court. It means that there should be consistent results across the state of Illinois, regardless of where a child lives, regardless of who their judge is. There should not be any kind of judge roulette in this situation. So specifically, the law amends 6 Illinois governing statutes: the Juvenile Court Act, which, as I said, governs abuse and neglect proceedings, as well as delinquency proceedings, the Probate Act, which governs minor guardianship proceedings, the Illinois Marriage and Dissolution of Marriage Act, which is divorce and custody, the Parentage Act, which governs custody and child support cases for unmarried parents, the Adoption Act, and then the Illinois Domestic Violence Act. The major changes that the law implements include that judges are required to consider SIJS findings. This is huge because a judge can't simply say, I don't want to, I don't think I have jurisdiction, I don't like that it says immigration law. They're required to look at it and consider it, and if the evidence supports the findings, they are required to grant them. So that's huge. It clarifies the definitions that we're looking at regarding abuse, abandonment, or neglect, because those definitions were defined differently in different statutes. It was a little bit confusing depending on what court you're in, which definition you want to apply to the child in question and the proceeding in question. And notably among those definitions, abandonment will now include a situation where one or both parents has died or where they cannot be found. So just quickly, I'll talk about NIJC's pro bono program because we want all of you lovely people to take cases from us to help the kids who we're working with. NIJC provides legal services for 10,000 plus non-citizens. We work on advocacy, we work on direct legal services, on federal litigation, and we work with a huge network of pro bono attorneys, as many of you are already aware. So there's a number of different pro bono opportunities at NIJC. Please feel free to talk to Ellen after the presentation if you have any questions at all about taking a pro bono case, but we'll be focusing specifically on SIJS cases and the predicate order piece of those cases. So just so that you know, if you do end up taking a case from NIJC for an SIJS predicate order, these cases are already screened. The child, the immigrant, contacts NIJC and needs an attorney. NIJC staff, like myself, conduct an in-depth screening to make sure that everything is as it should be to place the case with a pro bono attorney. And then we sign a retainer with the client, and we provide ongoing extensive technical support as these cases move through the courts. So we have a well-developed pro bono program. Again, if you have more questions about that, feel free to talk to Ellen or feel free to talk to me after the presentation. So I'm going to talk briefly about the statutory authority for SIJS before I turn it over to Meredith for the nitty-gritty of filing this case in the custody context. So these are the governing statute regulations and guidance for reference. So the statutory requirements for Special Immigrant Juvenile Status are that a child has to be under 21 years of age, unmarried, and present in the United States. This is notable, and we'll get into this in the section on filing in state court in Illinois. While a child has to be under 21 to file for immigration purposes, in order to get an order placing a child in custody in the state of Illinois, they have to be under 18. So in Illinois, in the custody context, we're looking at a younger age. Then the predicate order piece that we're going to go into is the child has to be the subject of a juvenile court order that places a child under custody of someone or declares them dependent. And the court has to find that the child's reunification with one or both parents isn't viable due to abuse, abandonment, neglect, or a similar basis under state law. And that court also has to make a determination that it's not in the child's best interest to return to their home country. So this is the predicate order that we need in order for a child to be able to apply for this special immigrant juvenile status. Without this order, without these specific exact findings, the child will not be eligible for immigration relief. And then the final requirement that the Secretary of Homeland Security consents to the grant, that just means the child submits their application and the immigration authorities approve it. So this boils down to essentially a three-step process. We're going to be talking about the first step, the state court order through a juvenile court with the special findings. And that's the subject of our pro bono program for SIJS as well. Once the child has that state court order, NIJC takes over to file the immigration petition. The SIJS petition is only the second step in a much longer process because after they file their original petition asking for approval of the findings that they are abused, abandoned, or neglected, they then have to apply for adjustment of status, which is an application for a green card. And the timeline on this in recent years has gotten much longer due to a variety of factors, including backlogs with the immigration authorities. So as you can see, the SIJS predicate order in Illinois has to be obtained before a child turns 18 in the custody context. The SIJS petition, so once the child has that predicate order and files their initial immigration application, it's taking about 18 months, maybe 2 years for USCIS to approve that. Step 2 in the three-step process. And then for many children, it's going to be another 3 to 5 year wait before they can get their green card. So this is the first step on a very long path of getting children this protection and stability so that they can continue to move on with their lives and heal from the trauma that they may have experienced. So the actors involved in an SIJS case include the parent or guardian of the child, and that would be the person who is your client in a custody proceeding. NIJC and the pro bono attorneys will be representing that individual. The state court is where you'll be bringing the predicate order case, and then after the predicate order is obtained, USCIS will be making the determination about whether to approve that child's application. So the reason that we'll be talking so much about state court is that this requirement that a juvenile court makes these findings is much broader, I think, than perhaps people think about. So the reason that the new law amended so many different statutes in Illinois is because all of those statutes govern in some form or another different forms of child custody. So this order can be obtained. We'll be talking today about a custody order in domestic relations court, essentially. But this order can be obtained as a result of a number of different proceedings, including child welfare, adoption, guardianship, and juvenile delinquency. So just to pause quickly before we move into the nitty-gritty of filing cases, are there any questions about this kind of section that I've gone over?
With some perception of immigration on the U.S., do you think that that is getting delayed even further? Applications for green cards?
I mean, I think there are a lot of factors. It's really difficult to tell what's causing the delays. I can tell you that delays at USCIS, U.S. Citizenship and Immigration Services, which approves almost all immigration applications for relief, the delays are across the board. And so some of that has to do with volume of applications. Some of it, I'm sure, has to do with internal policies that are changing. And yes, I think it may be affected by kind of the general climate as well. Hillary, sorry, go ahead.
What's your timeline of 3 to 5 years to get the green card? Presumably, so long as the application was made before 21, they're still eligible? Correct.
The TVPRA, which created modern SIJS, included age-out protection. So as long as the child submits their application prior to 21, they should be protected throughout that whole process.
That's what I was going to ask you
Yeah.
to clarify. Yeah.
Yes.
Hillary, you mentioned the three prongs of the predicate order, placing the kid with an entity or a person, finding that the kid has been abandoned or abused by one or both parents, and then the third one that it's not in the kid's best interest to return to home country. I was curious, have you seen any pushback from the judges on that third prong? Like, well, I don't know whether it's in the best interest, or are they accepting country conditions and the family's affidavit as sufficient?
Great. So the question was, as far as the three prongs of SIJS, which are custody determination, abuse, abandonment, neglect, and then not in the child's best interest to return, whether we see pushback from judges on making a finding that it's not in a child's best interest to return to their home country. We have fortunately had great success in our pro bono program. For example, the judges here in Cook County, the judges at the Daly Center now seem to be very familiar with these cases and are willing to enter orders based purely on testimony of the parent and sometimes of the child. I have heard of judges so we work with a good pro bono partner in Champaign County, and judges have wanted testimony about specific conditions in home country. I think at one point she brought in an expert witness. Usually I would say that would not happen in the Daly Center simply because of time considerations. But I think the important thing to keep in mind if you do encounter pushback is that a best interest finding is completely within the purview of a judge in any one of these types of proceedings, but particularly in a domestic relations proceeding. This is something that you can calculate based on conversations with the family, based on conversations with the child. You don't have to be an expert in the home country to determine that based on parents' testimony or based on your previous findings that the other parent in home country has abused the child, it really is in the child's best interest to stay here and not to return. So I think education around that point is really important, but I think to your point, one other thing that the new law changes that will be really important for our clients is that evidence can consist solely of a child or guardian's testimony. Yes, Mary Meg.
I recognize the law doesn't go into effect January 1, 2020, but have we seen any changes since the law was signed by the governor?
You know, as I said, most of our cases right now that are pending are in Cook County, and we have, for the last couple of years, had great success in Cook County already. So no, I haven't had any feedback that someone has specifically cited the law as the difference between whether they would grant a case or not. I think it has been really helpful to include in our memos to the court about why we're making this request, to be able to say this law has passed, this law will be in effect, and here's all the supporting evidence of why this is a legitimate request in Illinois. Yes, Amy?
The guardianship, the immigration status of the guardian, is that, I know that some judges are nervous about appointing guardians to status.
Mm-hmm. So Julian actually mentioned a bill that recently passed that addresses that issue. I don't remember the bill number.
SB 1429.
SB 1429. So that specifically says that in Illinois, the immigration status of a litigant cannot be considered unless it's specifically relevant to a case. So you may get pushback saying that it's relevant to the case somehow, but I think generalized fears about somebody perhaps being in danger of deportation, I would say that that's not a specific enough concern to make it relevant to a case. So at this point, I would cite that new law saying the status is not relevant. We can't talk about it. We're in fact legally prohibited from talking about it. But I think other than that, you continue to make your arguments. If this is a child's guardian, if this is who the child has been living with, they've been able to protect the child, their immigration status shouldn't come into play unless that person is actively like on a plane about to be deported. There's some sort of imminent separation.
And I think also Rebecca, I'm sure, can speak more to this, but I think there has been a shift in Cook County on that attitude in at least the last few months or the last year, so that's less of an issue now.
Yeah, there's a new, hi, I'm Rebecca, I do guardianship. There's a new judge in the minor guardianship program. Unfortunately, guardianships are no longer being heard in disputes. So you used to be able to take guardianship to two different places in Cook County. County, and now they all have to go to the day center. So one courtroom before one judge, and so that has been an issue for us historically. But we have a new judge in the minor guardianship courtroom, Stephanie Miller, and she is appointing undocumented guardians of children. So that's a really positive development that we've seen that should be a major improvement for our families and our community. And also, as soon as she took the bench, I asked her, like, hey, what about SIJS? And she's like, I don't know what that is. She has also shown very much an openness. We've got a case that Jeannie Gillespie is handling that we're waiting for. So we're hoping that this will be a complete turnaround in that courtroom.
Right. So for those of you online, a great update from Cook County is that a new judge in probate court has been now appointing undocumented guardians for kids, and also has seemed to demonstrate some openness to making SIJS findings. And we do have a test case that will be coming up soon, and we'll see how that goes. But I think the combination of the judge's openness and this new law will clear the path, I think, for many kids now to be able to, whoever their guardian is, go forward and seek those SIJS findings. So let's move into the nitty-gritty of filing a case.
Before I get started, I'm just sort of curious, how many of you have done a predicate order, either with NIJC or otherwise? Okay, it's a good number. And separate question, although I'm sure there's some overlap, how many of you have handled cases in domestic relations, guardianship? Okay, wonderful. Good, pretty good, oh yeah. Okay, so first question is, what kind of case do I file? And I know when we've given these presentations before, people feel like, what do I do? This is a whole separate area of law. But the good news is these are actually a result of the same types of cases that are filed every day in these courts. So for purposes of our presentation, we're going to primarily be focusing on allocation of parental responsibilities and some non-parent allocation of parental responsibilities. For those of you who don't regularly practice in these courtrooms, allocation of parental responsibility is the newer term for what generally is thought of as custody. So we'll probably use those terms interchangeably, but the word custody in and of itself no longer exists in Illinois law. So just to clarify on that issue. So steps to obtain a predicate order. First, you'll meet with the client, and as Hillary indicated, NIJC, when you're taking cases with them, will have previously screened them, so you don't need to worry about figuring out whether they're eligible for this, but you'll still need to get a real sense of their story, get a sense of how it is that the child came to be with whatever parent, guardian that they're with right now, and an understanding of what it is that you want to file. Next, you're going to draft and file the petition. We'll get into the details about that. Then you're going to talk about service. Are we going to do personal service, publication? Is it possible that the other parent will consent or both parents will consent? Once you've then completed service of process, you'll wait for a default date or a hearing date. That'll be scheduled. You'll then prepare the client's testimony and you'll prove up the case at a final hearing. As soon as that's done, you'll of course notify NIJC of the decision and then they'll take over from there. So for purposes of this training and for the pro bono work, it's only about that predicate order. NIJC takes it over from that point and handles all of the immigration side. So first step, as mentioned, is meeting with your client. This is really important. Your client is the petitioning parent or guardian. It says, if necessary, meet with a child separately to preserve trust and confidentiality. In some of these cases, depending on the child's age, you may or may not meet directly with the child. If you have a little kid involved, it's probably okay to just be meeting with the parent. Often these cases come to NIJC, as they do come to me, or you might encounter them elsewhere when the child is 16 and a half, 17. In those cases, you probably do want to meet with the child, make sure that their story makes sense along with the story of the parent or guardian, just make sure everybody's sort of on the same page and has the same understanding of the facts involved. You want to review NIJC's referral information with the client before filing anything in court. This is really important, and this is true even outside of work with NIJC. I'll get into this a little bit later, but I've done a number of these also working with private immigration attorneys who have taken these on. A big issue is some immigration attorneys say, okay, first go to a family law practitioner, get that predicate order, then come retain me as an immigration attorney and we'll take it from there. I personally never take those cases because I'm not going to get into this predicate order unless I know there's an immigration attorney on board. They're ready to take it over. They've already approved this. And also that I can speak with the immigration attorney or NIJC and make sure that we are all on the same page about all of the details of the facts. I can't tell you how often I've seen predicate orders that then don't match what's filed on the immigration side, or some confusion, even about little details that, of course, can raise suspicion. So just be very clear that you're reviewing everything that NIJC gave, you're confirming that with the client, you're confirming that with the child if necessary, and if there is any discrepancy, reach back out to NIJC, make sure there's clarification because this can be critical. Similarly, work with an interpreter if you have non-English speaking clients or if you don't speak their first language to ensure that the client understands the entire content of the petition and the process. Often clients are so eager to get these done, especially if the child is about to age out of the system and you have clients who are in a desperate situation, they just want to get it done. It is so important that they understand every word in a petition that they are signing. It is so important that that's clarified before anything is filed. And also same goes for when they're ready to speak at the final hearing, that they know everything that you're going to ask them and you are sure what their answers are going to be. It's also really important to discuss risks with family members before filing anything. People need to understand that this is not a guarantee necessarily. There's not always a guarantee that you're going to get the predicate order. As Hillary said, we've been very successful about these. Thankfully, Cook County, that hasn't been a big issue, but it's not 100% guaranteed. Number two, even if the predicate order is granted, it's not an immediate guarantee of status on the immigration side. This is confusing. This is confusing to us as attorneys to understand this process. It's extremely overwhelming for clients at times to understand that getting this first petition doesn't mean that there's guaranteed immigration relief, that there's sort of these two systems working in conjunction with each other, that state court is different from the federal system. They need to understand that there are risks involved in this. Obviously, also, you're dealing with people who are undocumented, and I think they need to understand, for lack of a better term, sort of outing them as undocumented people and subjecting themselves to the court system. Again, in Cook County, we've been very lucky in this regard, but their information is going to be part of a public filing, and they need to be consenting to that and understanding that that could have potential risks. Again, any questions on these issues, always refer back to NIJC. They're the experts on this. Next step is drafting the petition. So once you've figured out what kind of case it's going to be, you have all the facts, then you're going to put the petition together. NIJC is wonderful in providing sample pleadings, instructions for filing, so you will not be on your own in this. Pleadings look like standard family court pleadings. So again, as I mentioned, they're not going to be that different from a typical petition for allocation of parental responsibility that judges are used to seeing every day. The difference here is that you want to allege facts sufficient to support the abuse, abandonment, neglect. You want to support the not in the best interest to return to the child's home country. And you also have to include a request for that SIJS finding in the prayer for relief. So you're just adding a little bit of extra language so that you're getting, at the end of the case, you're going to be getting the same sort of order that you would get in a custody case anyway, but it's going to contain this additional language, which is then helpful for filing the SIJ, for the SIJS relief. You also want to avoid any mention of the parent or sponsor's involvement in the child's journey to the United States, if that makes sense. So if you're asking that the court place the child in the custody of the one parent, you don't need to get into the details of how that one parent may have brought the child here.
And I'll just jump in. That's one piece that when I review these pleadings with you, that's kind of what I'm looking for, is to make sure that there are sufficient facts to present your case to the domestic relations court in this case, but not so many facts such that it could potentially prejudice the child or the parent when we submit all of this information to the immigration authorities, because we really want to keep information about everybody's status and anything anybody may have done or not done with respect to any immigration violations to a minimum, so that we can make those arguments as necessary before the immigration authorities.
So you're sort of treading lightly here, right? Because you have to have enough that's sufficient to get the findings you want, but not so much that, not more than necessary. So Hillary can be helpful with that in sample pleadings and also in reviewing pleadings and making sure. And again, even if you're doing these at some point outside of work with NIJC, that's why it's so important to have an immigration attorney already on board. I always have immigration attorneys review everything before it's filed, all the final orders, so that they're sure that nothing's going to cause problems on their end. Next, we're talking about the magic language. So I know this has been brought up a number of times already this morning. The language in the petition should mirror the absolutely necessary findings you want in the final order. So the end game here is the final order of the court. That's the piece that then the immigration attorney will take with them. That order must contain these three pieces of language. 1, child's reunification with one or both parents is not viable. 2, that's due to abuse, neglect, abandonment, or a similar basis under state law. And 3, it would not be in the child's best interest to return to her home country. So the final order that you'll get will contain other information. It'll look like a final custody order or a final guardianship order, but it must additionally contain this exact language. Do you want to talk about this?
Sure. So these are just a comparison side by side of the definitions that have changed with this new law. And this is great for those of us doing this in courts because it's just much clearer now what definitions we're using. So for example, let's say in an allocation of parental responsibilities or custody case, abuse was already defined in the IMDMA, which is the governing statute for custody cases in Illinois. And it refers to the abuse definition in Domestic Violence Act, which includes a number of factors, I think physical abuse, intimidation, etc. So that definition has stayed the same, but is now present in every single custody statute in Illinois. Abandonment is not defined in any, or is currently not defined in any of those statutes and will be under the new law. What we have been doing up until now has been using the abandonment provision found in the Uniform Child Custody Jurisdiction and Enforcement Act, which is sort of a, as it sounds, it's simply about jurisdiction in custody cases, and that's been helpful in some cases and confusing in others. So now in each Illinois statute governing custody, that definition is enshrined. So the new abandonment definitions includes, but is not limited to, a failure of a parent to maintain a reasonable degree of interest, concern, or responsibility for the child's welfare, or when one or both of the child's parents are deceased or cannot be reasonably located. This is great. This is huge for our kids because if a child, for example, is living with mom is the only person who can provide care, and dad is simply deceased, so they can't go back to home country because they don't have dad there, they are now eligible because dad can be legally said to have abandoned them. And we previously made the argument that the UCCJEA definition would apply in those situations because a deceased parent obviously cannot provide reasonable and necessary care or supervision, but it's really nice to have that simply codified so it's very clear. Similarly with neglect was mainly defined in the Juvenile Court Act for purposes of child abuse and neglect proceedings and other relevant statutes to those types of proceedings. We had been using a neglect definition sort of in reverse, failure to perform the enumerated parental caretaking functions that were found in the IMDMA covering custody cases. Now those definitions are codified in each governing statute. So it does include the failure to perform those caretaking functions, and it specifically references the already existing neglect paragraphs in the Juvenile Court Act. So for example, if you're in custody court before a judge and they say, well, why would I be able to make a finding under a Juvenile Court Act definition? That's not my governing statute. You're able to say now, but it is now included cross-referenced in your governing statute, which is important.
Okay, so again, in your petition and in the order, you want to cite to the appropriate definitions and provide supporting facts. For those of you who may have done these some years ago, I know myself included, it used to be okay to have kind of a bare bones order that just had that language and a few other things. Now my understanding is they really need it fleshed out a little so that the petition itself and the order provide some supporting information as to why those findings are there. So Again, respondent neglected the minor children by failing to perform caretaking functions and then cite the statute. You can give examples: failed to provide food, shelter, economic support, be as specific as possible as far as timeline, had substantially no relationship with a minor child since they were 3 years old. Again, this is where it's going to be important that you look at notes from NIJC about what came out at the intake, and you again confirm this with family members. You know, I'm sure NIJC will have done a really thorough job, but sometimes a new memory comes up or some other information, or someone has since thought about it or talked to other family members, or in talking to the child. So often new details come out, and that's why it's so important to make note of those details, confirm them with anybody else involved, and again, get back in touch with NIJC and make sure that everyone's on board. Once you've prepared the petition, you will file it. As most of you probably know, e-filing is now mandatory in Illinois. Here's information on how to register in Cook County. And do you want to say anything further about fee waivers for NIJC?
Sure. So it's really important to note that for pro bono cases from NIJC, we don't expect either the pro bono or the attorney to pay fees in court specifically. NIJC clients should all be eligible for a waiver of fees called a CLSP, which stands for Civil Legal Service Provider. Illinois law provides that individuals who are clients of a civil legal service provider or have been determined to be under, I think, 150% of poverty should be eligible to have all their fees waived. With e-filing, my understanding is this gets a little trickier. So when you have your case and you're filing it and the CLSP is not uploading or the drop-down menu is doing weird things, call me and I'll probably tell you to call e-file tech support. But this is something that, working through it, we've mostly been able to manage, and that should then waive all fees involved in the case. That should include filing fees, it should include transcript fees, it should include any other fees that would relate to the case. So we're not expecting you to outlay the money to do this, although some firms have chosen to do so just to avoid the whole e-filing with the CLSP issue. But that is something that all NIJC clients should be eligible for.
So once you're filed, you then need to determine what type of service you're going to use. This is a little tricky, and I'll get into the details of this. If your respondent parent signs a consent or waiver, you can request the final hearing right away. And I'll talk more about this. You might be surprised to even think about the idea that someone would consent or sign a waiver. And I see some people making faces. So maybe those of you who've done these have seen this actually is pretty common. And in fact, if possible, this is by far the best way for these to proceed. So, you know, you might think, well, if somebody abused, abandoned, or neglected their child, why would they now help out by signing off on this case? But I've been very successful in these. I know many other attorneys have. I mean, many people who haven't seen their child in a number of years maybe feel like, well, if this is going to help them, great. Or they do acknowledge that they don't have a relationship with their child. That's true. So, you know, in the event that this family knows where the other or both parents are located, that is very important to first explore what it might mean for that person to sign a waiver and consent, if that's even possible. Time is of the essence often in these. As I said, if you're getting a case where a child is 17 and a half and you're thinking about service issues and trying to locate someone, if there is any chance that that other parent or both parents, that their whereabouts are known and that they might agree to this, that's going to be your best form of action. As this says, if they sign it, you can request the hearing now. Things can move slowly in the court system. You could show up for a final hearing and realize you needed some other information. The judge might request something further. So the sooner that you can get moving on these, the better. And if you can get a consent, that's wonderful. If not, you then need to determine how service will be made. Most of you are very familiar with this. This slide just sets forth service in Illinois, service out of Illinois, service in a foreign country. The very nature of these cases, as you can imagine, it's not very common that you're getting service in Illinois or outside of Illinois. You're almost always looking at the other parent being in another country. It's possible that the other parent is here, but it's less likely. So again, if you're looking at a parent in a foreign country, your best bets are really going to be consent and waiver if their whereabouts are known. And of course, if their whereabouts are unknown, then you're going to be looking at a publication issue. I would say in the vast majority of these, it's going to be one or the other. If their whereabouts are known and they're not consenting, that can bring up some other issues, and it can be a more complex process, obviously, as far as figuring out service. I'll just briefly touch on Hague Convention. There are other ways of obtaining service in foreign countries. I don't know if anyone has successfully gone through that process. I had a case in a divorce a couple of years ago. Long story short, it took about 2 years and it still didn't work to go through Hague, and it's very expensive. So again, you might think, oh, well, Hague, foreign country, no big deal. It is a big deal and it takes a long time. So that's really going to be a last resort, probably of a little bit more leeway if you get a child who's very young and time is not as big of a concern. But that's, I would say, almost a non-option if you're getting a child that's 16 or 17.
And I would say the majority of our clients right now are from Central America, and the countries that they're coming from are not Hague countries. Mexico is a Hague country, which is important to note, but a majority of our clients right now are not Hague countries, and so we don't come across this issue. If we do, it will be flagged and highlighted and starred in our referral.
So safe to say, any cases that they would be taking from NIJC, you'd be looking at publication or hope for consent or, okay. So again, most common service options: personal service in or outside of Illinois, publication if their whereabouts are unknown, and again, consent and waiver. And noted here, even an abusive or neglectful parent may be willing to sign a consent and waiver. I can't stress this enough. Don't just think, well, there's no way that parent's going to help out. Really talk to the family about that. I know in some cases too, one parent might feel a little hesitant about getting that other parent involved. This is a sensitive topic. If this is someone who was abusive to the family, if this is someone who has not been in touch for many years, it's not going to be an easy conversation necessarily to say, hey, why don't we reach out to this person and see if they're willing to help? But it is important that they understand what this option could mean as far as how quickly it can get the case in court and how much easier it can make it. And again, if they know the whereabouts, then publication is not an option. So this is an important and delicate conversation to have with families. And here, again, service and jurisdiction are different. So service, as you know, is about properly notifying the opposing party. Jurisdiction is a whole different issue, and this can be a little bit tricky in these situations. Again, if you come across difficult jurisdictional issues, Hillary is the master who can help you resolve these issues. So if the person has never been to Illinois, the court might not have personal jurisdiction over them, right? If this is somebody who is residing in a foreign country and has never been here, then you probably don't have personal jurisdiction. Now, the court definitely has subject matter jurisdiction over custody for any child that resides in Illinois. So that's a UCCJEA issue, and there are separate slides on that. So you may or may not need the court to take personal jurisdiction over the respondent, depending on the type of case. If that is true, there are a number of bases upon which a court may assert personal jurisdiction over a non-resident, and we'll get into that momentarily. But again, and I know I'm harping on this, this is why consent and waiver is so important, because that allows the respondent to submit to jurisdiction, waive service, and you can skip all of that and just move forward. So as far as jurisdiction, here are the relevant statutes. Illinois Parentage Act of 2015 speaks to subject matter and personal jurisdiction. The Uniform Interstate Family Support Act talks about jurisdiction over a non-resident. UCCJEA, as mentioned, also touches on jurisdiction. Now, it comes into play most often in a parentage action. So if it is a custody-only matter, if parentage has already been determined, then UCCJEA says, not an issue, you have subject matter jurisdiction through UCCJEA. If you don't yet have a finding as to parentage, that is when personal jurisdiction is necessary. 750 ILCS 46603, court needs personal jurisdiction to declare an individual the parent. Court may exercise personal jurisdiction over a non-resident under certain circumstances. So if the individual submits to the jurisdiction, such as signing the consent and waiver, if the child resides in Illinois as the result of the acts or directives of the individual, and any other basis consistent. So this is important. If you know who the other parent is, but there has not been a finding, you are asking the court to make a finding as to parentage. You need personal jurisdiction in order to do that. Yes?
Does the kid's birth certificate count as a finding of parentage?
That depends on where the birth certificate is from, right? So in Illinois now, birth certificates are issued with a parent's name after the father usually has signed a VAP, right? A voluntary acknowledgement of paternity. So depending on the year of the birth certificate, here you would be able to say, yes, parentage has already been established. That's something that we screen ahead of time. So essentially for NIJC clients, this is something we'll be trying to establish pretty much only if the parent's name is not on a birth certificate. In most of the countries, based on the research that we've done that our kids are coming from, there's a similar process. A father's name can't be placed on a birth certificate without that father's consent and voluntary acknowledgement. Regardless, for the purposes of the immigration application, USCIS will accept parentage as already determined if both parents' names are on the birth certificate. So yeah, for purposes here, it's if the one parent's name is not on a birth certificate that we'll be requesting the court to establish parentage. And in those cases, we do rely heavily, quite often, either on the other parent signing off and submitting to jurisdiction, or we rely heavily on this acts and directives provision for taking personal jurisdiction over a non-resident. Usually in an SIJS case, that's pretty straightforward, right? Because an abused, abandoned, or neglected child has somehow made their way to the United States, usually because of that abuse, abandonment, or neglect. So if that one parent or both parents hadn't committed those acts, the child would not be here in the state of Illinois. We haven't had to specifically make that argument before a court yet because we just haven't had an issue with challenges to jurisdiction, but we're going to have one, I think, coming up soon. Judy will be bringing a case like that shortly. And I think we have a solid argument based on these bases for jurisdiction over a non-resident.
And so again, I mean, in my experience, and I believe in most other people's experiences, this is usually not a huge issue. It's unlikely that you're going to get there and the judge is going to be making a big deal about this. You know, you're going to set forth certain things in the petition. This is already going to be screened by NIJC, but it's something you should be aware of in talking to the family and just figuring out holistically how your case is going to go. Again, touched on this briefly, the UCCJEA, and you have further language there. This is important primarily because of the home state, which says that the state in which the child has lived with a parent or person acting as a parent for at least 6 consecutive months has jurisdiction. So that is why Illinois has jurisdiction on most of these cases. And again, this is about subject matter jurisdiction, not personal jurisdiction. Final arrow there again is the distinction between parentage and custody. So if it's not a parentage case, then that personal jurisdiction is not an issue here. You're just talking about subject matter.
I would also point out, just in terms of the UCCJEA, we sometimes have these orders coming in on emergencies, right? The child has just arrived here, they're 17 and a half. They need to file in court right away. They can't wait for 6 months to have passed for them to reside here. And I think in that case, we've been able to successfully move forward despite not the child not having resided here for 6 months. I think for a couple of reasons. One, if the case is uncontested, then nobody's contesting jurisdiction, so this isn't even raised. I think two, if it were raised, if the judge were had concerns about that, typically, again, by the nature of SIJS cases, a child may not have been living with a parent or person acting as a parent immediately prior to coming to the United States. These often are kids who are on their own or who are bouncing around. So again, it's an issue only when it becomes an issue, but typically there are ways around it and ways through it for kids who need to get into court right away.
Yeah, so if you see that the child has not been here for 6 months, that should not be a reason to wait on your case. Speak with Hillary about this. So preparing for the final hearing. So once you have everything filed, the other person has been served, then you're going to be thinking about the final hearing, which is what you need to get that final order. Hearing date may be 2 to 4 weeks out. It's going to depend sort of what judge's calendar you fall on. That's, again, something that you need to be factoring in. So that order has to come before the child turns 18. So even if you filed your petition before they turned 18, you have to get that final order in before they turn 18. So again, when you're getting kids that are really close, make sure you're verifying their birth date, you're speaking with the immigration attorney or NIJC, and you have a solid timeline with enough wiggle room if something needs to be changed. Courtesy copies, often due to the judge 1 to 3 days prior to the hearing. Depends on the judge. You can look at a judge's standing order to figure that out. Again, due to the reunification not viable requirement, the SIJS hearing almost always proceeds by default or consent. Again, these aren't contested matters. So if the other parent said, oh no, I don't agree to this, I'm contesting this, then it would be really hard to make an argument that reunification is not viable if the other parent, for example, shows up in court. If that happens, or you're trying to figure out a consent waiver situation, the other parent says, oh no, I'm showing up, I do contest this, that's when you want to contact NIJC right away, because that's a huge game changer, and they need to know about that. You should not be showing up for the final hearing with the other parent there ever in these cases. If the other parent shows up, call Hillary.
that becomes a contested case. And I think that the reason is that it's not just the existence of the abuse, abandonment, or neglect. It's that the court is entering a finding that the child can't be reunified with that parent. While that is not the same thing as, for example, terminating a parental right, which would happen in an adoption case or sometimes in abuse or neglect proceedings, it's very strong language. So even if there's been bad abuse, quite often if the abusive parent is showing up and saying, I do want visits with my kid, the judge is very likely to order those visits. Maybe they'll be supervised,
right.
Therapeutic. So like some provisions will be in place to protect the child, but the judge is not likely to say the child cannot be reunified absent egregious circumstances. So if somehow it becomes contested, call us right away. It's another one of those things that we screen for ahead of time, but let us know.
And again, so motion for default. So for example, if you serve them by publication or personal service and you don't hear anything further, you do need to go in on a motion for default. Sometimes the default order is entered at the same time as the prove up and final hearing. Sometimes it happens ahead of time and then the final hearing is scheduled, but that's going to be 30 days after the personal service or publication. Or again, you can move forward right away if it's consent or if the other parent is deceased. Then before the final hearing, you want to prepare the client testimony. I will say in my experience, and I'm sure you all have had different experiences, I've had judges who have wanted a lot of client testimony. I've had judges who've wanted little to no client testimony. So, for many clients, this is going to be their first or one of their first times in court. They're probably going to be very nervous. I would suggest even just fully writing out your questions, practicing with them ahead of time, letting them know that the judge might ask some additional questions or clarification questions. But, also I think they should know it's unlikely that somebody's going to be grilling them or that it's going to be a scary situation. For the most part, it's going to be their chance to state most of what's already in the petition. The judge already knows what's going on, but they're confirming this information. Again, you want to explain all of these questions ahead of time. Do not ask something that you didn't practice or discuss with them. You don't want any surprise answers. And again, the judge may ask questions. I think the more questions you ask, the less likely a judge is to ask questions. So the more thorough you can be and prepare them on exactly what's going to be asked is better. Young children are not allowed in court, and older teens should wait in the hallway in case the judge wants to speak with them. So if you are dealing with a case that's a really little kid, that kid does not need to come to court. That kid is not going to be expected to testify. Older teenagers, it's possible, but again, it's not that it's all going to be on them, because the petitioner in this instance is the adult who is requesting this relief, not the child. The court does have official interpreters. So if you are in this case, check in with the clerk as soon as you get there and let them know. They often have to order the interpreter, and there's only 1 or 2 running around the courthouse, so it can mean you're waiting a really long time. If you have the option of bringing your own, it's much faster. You also might It might be someone that your client has met, feels comfortable with, you know, they understand each other, and that's a little bit more comfortable for your client. Again, and I know I mentioned this several times, communication with the immigration attorney is the single most important way to ensure your client's needs are met. The immigration attorney must review your petition before it is filed. They must review your final order. Now, I know sometimes you get there for the final order and the judge wants a few additional words, or you have to make some last-minute modifications, but to the extent possible, if the immigration attorney is completely comfortable, they've cross-referenced all of your facts, they've checked it against everything that they're going to file, they've checked it against all of their communication with the client, it is so important. Again, I have seen this so many times where people do really detailed interviews and something is off, and maybe it's an interpretation issue, maybe it's a client memory issue, but you want to catch that before things are filed because it's so much easier to fix ahead of time. Once you're before the judge, know your judge, check standing orders. Some of this is from older slides. Hopefully this will be less of an issue now. So if judge is uncomfortable with SIJ findings, you might bring a memo of law. You know, with the new law, hopefully a lot of this is going to go more smoothly. A lot of what Hillary was talking about before is just that these are unusual findings for judges. So in the beginning, when judges weren't comfortable with this, they maybe have never heard of this. These aren't the kind of typical findings they're making. You had to be really prepared to educate them on what this meant. Hopefully this is going to be less of an issue now. I guess a question for you, is there going to be some judicial education, or will they know of this, or will they be relying on attorneys to be bringing this to them? Any thoughts on that?
So we have actually been in touch with Judge Dickler. We did a training for child representatives this summer that talked a little bit about the details of this new law and its upcoming effective date. And Judge Dickler, I think, used to be an immigration judge, actually, so she's familiar with this. As far as judges in the rest of the state, that's something that we're working on. We need to try to figure out how to do that judicial education. But yes, it's possible if you file a case, you know, January 2nd outside of Cook County, you will be the one educating the judge about the requirements of this new law.
Oh, an Illinois case law. Do you want to talk about?
Sure. So we previously talked about this case a lot. In the absence of any new law on this issue, there was a relatively recent Illinois appellate case on the issue that essentially said, yes, Illinois judges, state judges have the ability to enter SIJS findings. Here's the SIJS framework. Here's how it works with current Illinois law. That was called In Re Nina L. Feel free to read it. It does do a really good job of kind of placing SIJS in context of state law. But again, we're hoping that this new law kind of obviates the need to point only to the case law on this issue.
And again, at the final hearing, you will direct your client's testimony, answer questions from the judge. The judge will enter that final order, and you will pass that along to NIJC, and then your role as the pro bono attorney is done. Any questions at this point? Any of those of you who have done these previously, it seems in line with what you've done? Yeah? Okay. Rebecca?
I might add one more thing. So we talked about this before, and I think this is still the case. These cases can't be brought specifically or exclusively for immigration purposes.
Oh, right.
So that's why we're to do them in the context of custody or a guardianship case. So I think maybe also, this may be obvious, but it's important not to mention immigration law. So I saw a predicate order recently that said this order meets the requirements of INA something, and I prefer to you guys that I think that's a bad idea to make any specific mention of immigration laws or leave.
Exactly, and that's actually this next section is USCIS guidance on issues like that. So yes, previously we were able to get predicate orders that basically just parroted the provisions of the INA, the immigration law, and that's no longer considered best practice, and those cases will get rejected by USCIS. So I can go into that. Do we have any other questions about the process that we just talked about? Do we need a break? We're actually doing okay on time. Yeah?
Break? Yeah. Seems like, yeah.
5 minutes? Okay.
Okay.
Started again just to kind of be respectful of everybody's schedules, and we make it done early. So just the last bit of guidance that we wanted to provide addresses really pretty much Rebecca's question about information regarding the immigration case being included in the custody case. So this is all guidance from USCIS. U.S. Citizenship and Immigration Services is the agency charged with approving or denying these petitions. And they have, over the last several years, really kind of evolved their guidance on how they treat these orders and what they think the orders should contain and what would make them sufficient in order to approve. We have basically learned this by the process of starting to get cases denied and rejected, and previous orders that were sufficient were no longer sufficient. So it's been a process. They issued some guidance in 2016 that includes some specific language that they do want to see and some specific things that they don't want to see. So we'll review that, and then we'll also review some things that we've learned just kind of by trial and error is submitting the order and having it kicked back to us for some reason. This is mostly just for your information. As we've mentioned, NIJC takes these cases back for the immigration piece. And mainly that has to do with the fact that we have to wait so long for a result. We don't want to place something with a pro bono attorney that they're just going to have to babysit for 2 to 6 years. USCIS has provided guidance on how it assesses SIJS predicate orders, specifically on the purpose, the factual basis included in the order, some specific language around paternity, and then specific language around the best interest finding. So these are just good things to keep in mind as you're perfecting your final order. So essentially, after NIJC submits the initial SIJS petition, if USCIS has any doubts or questions about the sufficiency of the application, they'll issue a request for evidence, or RFE. And that can be months or years after the SIJS petition is filed, meaning in many cases, the custody case is over, the child has turned 18, there's kind of no going back. So what we do is ask the pro bono attorneys to provide us with a copy of the complete state court filing, everything that's been filed and ordered in court at the end of the case, so that we can then use that information to respond to USCIS. We have in the past had to come back to a pro bono attorney and say, hey, can we try to get this amendment in this order based on what USCIS is requesting? And again, we've had really good luck with really flexible and welcoming pro bono attorneys, and we've had really good luck with judges being willing to make these amendments sometimes in the best interest of the child, or just to clarify, yes, this is in fact what I meant in this order when I agreed to sign it as the judge, excuse me. So the first piece of USCIS guidance is about the purpose of the order. And again, USCIS has a final say to approve or deny a petition, and they can do that based on whether or not they think it's bona fide. Per their regulation, they are not supposed to look behind the state court order. They've delegated the authority to make these findings to state courts, and really they should not be going behind the reasoned judgment of a state court judge to say, we don't think that this is sufficient. And so what they say is they're just looking to make sure that there's sufficient factual basis listed in the order such that they see that the state court judge made a reasoned judgment. What we find is that it's often kind of going back to try to do that second guessing, and we always include that in our arguments back to USCIS, that this state court judge was fully informed, they made the decision, they're the ones with the authority, but in addition, if we have the opportunity to make amendments in the interest of our client, we try to make that happen. So the first piece of guidance is about the purpose of filing. USCIS wants to see that SIJS was not sought primarily for the purposes of obtaining permanent resident status, rather than for the purpose of obtaining relief from abuse, neglect, or abandonment. To me, this is a little bizarre because the reason that the child is typically here is to obtain relief from abuse, neglect, or abandonment, and a huge piece of that is obtaining stability of a lawful immigration status. I also find it strange that Congress has created this remedy, specifically delegated the authority to state courts, but then is saying, don't actually apply just to get your immigration status. It's very weird to me. And we, again, make that argument in our responses to USCIS. That being said, we want to try to carefully draft these orders to make sure that we can show that really a custody order of any type is a benefit to a child in a family outside and beyond the immigration benefit. Anytime, for example, an immigrant family who may not speak English is able to have a official order from a court in English making clear the relationship, I think especially now in days of family separation, increased immigration enforcement, that facilitates a lot of things, from law enforcement and systems interaction to schools to making emergency medical decisions. So we try to make that clear in our petitions and in our findings, that there are lots of reasons that this is being sought in addition to seeking immigration status. Mixed motives are okay, so it's fine when you're going before the judge and you're having to explain SIJS, you're saying, of course we're seeking these findings because we want to get this immigration benefit for this child's stability and well-being, but also here are all the other reasons that we're coming to you, Judge, with the 17-and-a-half-year-old seeking this order. So Meredith touched on this a little bit. Previously, we were able to submit orders that simply said, parroted the language from the INA, reunification not viable due to abuse, abandonment, neglect, not in best interest to return to home country. That's no longer going to be sufficient. We do have to be very specific in applying law to facts in each of the findings. So instead of saying Maria's reunification with one or both parents is not viable due to abuse, abandonment, or neglect, we have to say specifically what the abandonment consisted of, why the reunification is not viable, and make sure that that's specific to your client and not just a recitation of the language. Questions about those two so far? No. So we did touch previously on paternity a little bit. As I said, if the child's birth certificate lists two parents, that's fine. USCIS then takes that to mean that paternity is established. But if the child does not have a parent listed on birth certificate and there are findings as to that parent, USCIS requires that paternity be established. And usually that's within the context of the state court case. That can get tricky if we run into issues of personal jurisdiction. I think there are, what we haven't tried yet at NIJC that we think sort of runs counter to this guidance from USCIS, and all of this guidance is based on their policy memorandum. It's not found in the statute, and so again, our argument always to USCIS is this is ultra vires. This is not necessarily statutory. For example, we've seen cases where father may have abandoned the child before the child was born. Father may be unknown. A child may, for example, be a product of rape, which we think would be a very clear example of parental abandonment and perhaps even abuse, right? And in that case, if we're not able to get a paternity establishment in state court, we would still make the argument to USCIS, your requirement that paternity has to be established flies in the face of the intent of this protection for children. So far, we haven't had to bring a case like that, but just so that you're aware, this is why we go over the requirements for personal jurisdiction and paternity, because in many cases, we do need to establish paternity. Questions about that? So finally, the best interest finding. The third and final magic language requirement is that it not be in the child's best interest to return to their home country. For USCIS, it's not enough for a state court judge to say it is in the child's best interest to stay here with the petitioner. It does have to specifically say not in the best interest to return to home country, and there have to be specific reasons for that. Usually, it's not in their best interest because of the very abandonment or abuse or neglect that they fled. More recently, USCIS has been saying that also is not enough, that there also needs to be a determination that there's no other appropriate custody placement in the home country. Yes?
What's the definition of custody placement in the home country? Is that beyond the other parent, or would it be another relative?
Yeah.
That sort of inquiry or not?
I have those questions too.
Okay.
You know, it baffles me because a state court judge in Illinois it's not really their job to interview every person living in Honduras to see if they would be an appropriate custody placement for the child before them who's living with their mother safely here in Illinois, right? It baffles me.
Okay.
And yet it is now being required by USCIS in these orders. And so we do ask for a general statement saying that. And usually that statement is based on You know, obviously reunification with the parent in home country is not viable. Perhaps child may have been living with a grandmother or an aunt in home country and they can no longer care for the child, or the child fled, you know, death threats from gangs and also happens to be SIJS eligible. And for that reason, it's not in their best interest to return, and no custody placement could protect the child from those particular conditions. So usually the conditions are there. There's not an expectation that a state court judge, as I said, you know, do home studies in other countries to make this binding, but we do ask for the language to be included, and usually it works. Is there a question back here? No? Okay, so the last stretch, the immigration attorney should file the SIJS application with that predicate order with all the magic language, if at all possible, before the child turns 18. And that's because then we're able to say that the custody order is currently valid at the time of filing. There have been some questions about whether we're able to file post-18. In previous years, we have been able to successfully do that if it was valid at the time that it was entered and the child simply aged out. Given kind of some responses that we've been seeing from USCIS, we just try as a best practice to file it before 18. So this is important if you end up taking an emergency case, for example, from NIJC with a 17-and-a-half-year-old child, you prove it up the week before the child turns 18, give me that order like the day that it's proved up, so then I can make the appointment to fill out the application and overnight it the day before. Like, don't wait the week and then, you know, I don't have it until after the child turns 18. At this point, the child's immigration case is not over. So as we said at the beginning, it's a long process. And I think it's important to remind families of that kind of throughout. It's going to be a long process. We've had great success on this first step, and now you need to move on to the immigration attorney to take the additional steps. Yes, Jeannie.
During the 2 to 4 or 5 years before they get their green card, are they allowed to leave the United States?
No. Yeah, until they've...
What was the question?
The question is, while they're waiting for their green card, are they allowed to leave the United States? So this remedy is available to children who are physically present in the United States. So during the adjudication of the SIJS petition, they have to be physically present in the United States. If their SIJS petition is approved, but they still are waiting for their green card, they could in theory leave, but they have no way to get back in because they don't have a green card or a travel document to leave. The other thing that I think my kids are seeing more and more, this process is taking a long time. They're getting older. They're turning 18, graduating high school, wanting to work. There is no work permit for this process while you're waiting for the opportunity to apply for your green card. This has to do with visa backlogs in the immigration process, but basically, once your SIJS petition is approved, for many countries, there's still a 2 to 4 year wait before you can even apply for your green card. Once your green card application is submitted, then you can request a work permit while that application is pending. But in the period while you're waiting for a visa to become available to submit your application, there's no work permit, which is we find really frustrating for kids who have come all this way, have been through abuse, abandonment, neglect, have obtained this order saying finally that they are approved as special immigrant juveniles, and they're just kind of in limbo. And often kids who are in limbo may get in trouble. And then we have additional issues once we try to request their green card. So the backlogs create a lot of real issues for kids. It's a real problem, but this piece of it, this predicate order piece that you all are hopefully helping us with is huge, because it at least puts them on the path that gives them this opportunity to get in this line. And then last really important piece, children who are granted SIJS may never apply for immigration benefits for either parent. That includes the non-abusive parent. That's the way that the law is. So we clarify that with families when we do our pre-screen to make sure that nobody's making any assumptions or depending on anything, but that's something that the family should be aware of. So that's all we have. Thanks so much for coming, y'all.
So for those that haven't signed in or found their ARDC numbers, please do so now. The evaluations are on the table. We also do have a case list right now of a number of cases. I believe just a few cases right now are pending in Cook County. We are also always looking for attorneys in Collier County, Kane, Lake, DuPage County. So this webinar will be available on our website soon. And if you have other colleagues that are out in those smaller counties or in southern central Illinois, down by like Carbondale, Marion, or over by St. Louis. Those contacts are really greatly appreciated, and that we can continue to make this benefit available for the children that need it. I will also say, what was I going to say? It slipped my mind. While there are just a few cases that are right now ready, I think there's about 4 of them. We do have quite a few in the pipeline, and so we're just basically waiting for some documents from the kids to get those out to pro bono training. So please, we'll be in touch. Hillary is here, I am here, we're all here. Steve Nallet is wonderful as well. We're so grateful for you guys for coming. So again, once you have your evaluation, Anna Karen, who is our wonderful paralegal on the Illinois Company Children's Project, will be able to hand you your CLE certificate if you need that for Illinois training on your way out. Other than that, we have also, for those that are interested in other CLEs or continuing to learn, next Tuesday we have a really exciting panel on working with detained asylum seekers. We'll be at Shift Garden, and so you're more than welcome to join. And there's a whole bunch of other things coming up. So thank you, and thank you again to Annie from DLA for making this all happen, and for the lovely donuts and bagel. Have a lovely day.
Yeah, no, I